Alrighty, everybody, I am going to be diving into criminal law for today. And I'm going to be going step by step for every single felony that you have to know in order to do well in your class. If you do not know these felonies, drop out of law school now. You're screwed if you do not know these felonies. Okay? I'm trying to help you, so listen very carefully. I wrote down two mnemonics here in order for you to understand the critical felonies that you need to know in order to do well on your written exam and also multiple choice exam. So let me go through it. I wrote down bar room kiss. That is for the common law. I wrote bark, and that is for the modern law. Okay? So what do these actually mean? What do these mnemonics actually mean? What are they short for? So let's go through it. We have burglary, arson, rape, robbery, mayhem, kidnapping, sodomy, sexual molestation under the common law. And again, you need to know these. The most important ones that come up the most would be burglary, arson, and robbery. Those are the most common ones, I would say, especially for written exams, and also multi-state. I don't know why the bar loves them, but they just do. And also when it comes down to sodomy and sexual molestation, they barely ever come up. Again, still know them. I'm not gonna talk about them in this video because again, it is that rare. They will never come up, but nevertheless, go in your criminal law casebook and just study them. There's no definitions, they're very straightforward. It's not difficult for me to explain it on here. That's why I'm not going to talk about it. Bark means burglary, arson, rape, robbery, kidnapping under the modern law. So it's very critical for you to know these things. So let's dive into exactly what these felonies mean, and let's make sure you do well in your class. Or even for those who are listening who are not in law school, who are just curious to understand what these felonies mean. When we get into burglary, burglary is broken down into common law and modern law as well as arson is. So let's get into burglary under the common law first, then we'll get into the modern law. So burglary under the common law, CL common law, means the breaking, element 1, entering, element 2, of a dwelling house of another, element number 3, during the nighttime, element 4, lastly, with the specific intent to commit a larceny or felony therein, element number 5. So let me just number it really quickly so you can understand. Because remember, on your criminal law exams and even in MBEs, you need to prove every single element in order to make the defendant liable or not liable for this crime. Therefore, let's get into what each and every one means. So the breaking, element number 1, means the defendant used his body or some type of tool to create a breaking, whether it's the defendant using his hands to open up a window, using a skull key to open up the lock on someone else's house, or even simply as the defendant using a baseball bat to break open a window to get inside the house of another. That's what breaking means. Entering, and it can be an inch, as long as the defendant's body or some type of tool that the defendant is using enters the house, even inches, millimeters, or even as obvious as the whole defendant's body going inside the house. That is an entering. And if the defendant is using some type of tool, let's say the defendant used a crowbar in order to pry open the window in order to get into someone else's home, that constitutes not only a breaking, but also an entering, because that crowbar not only broke into the home, but also the crowbar got inside of the home by a little margin. So that constitutes an entering. A dwelling house of another, very straightforward, right? Someone else's home, someone else's condo, apartment, their mansion, as long as it is a place where that person dwells in, sleeps in, that is the dwelling house of another. So the defendant must be breaking into someone's actual dwelling. And the common law has this critical element as well, during the nighttime. So it'll really be sunset to sunrise. That's exactly what that means. So during the nighttime means sunset to sunrise. And it must be done during the nighttime. Usually the facts of the fact pattern will tell you that it's 11 p.m. or the sun is down. Something like that in the fact pattern will indicate to you that it is during the nighttime. If it is during the day, then the defendant may not be liable for burglary under the common law. It must be under the nighttime, or during the nighttime, excuse me. And last but not least, which is the longer element here, is element number 5, is that the defendant had the specific intent to commit a larceny, which was a felony under the common law, or felony therein. So basically the defendant needed to have that felonious intent before the defendant entered the home. Before the defendant committed the breaking, before the defendant committed the entering, etc., the defendant must have had the requisite plan, the requisite intent to commit a larceny or felony therein. And as we all know, larceny just means simply the trespass, retaking, and carrying away of another's property with the intent to permanently deprive that person of that thing. Okay? Example, shoplifting. But in this case, someone is going inside someone else's dwelling house, right? Dwelling house of another, during the nighttime with the intent to steal something within that person's home or commit another felony therein. It could be a larceny or a different type of felony that the person wants to commit within that home. But again, they must have that intent before they commit the breaking and entering. An example of this is, let's just say that my friend Riley wants to break into Arnold Schwarzenegger's apartment, right? Example, Arnold's apartment. So let's say that Riley tells me, hey Sam, I want to steal Arnold's bodybuilding trophies. That is my plan tonight, I'm gonna do it. And Riley gets his ski mask on, etc., and he breaks into Arnold's home by using a baseball bat to break open the window. He enters by putting his whole entire body within Arnold's apartment. We already know that it's dwelling house of another because that is Arnold's apartment. And it's during the nighttime because Riley informed me that he's going to do it during the nighttime. And again, it's sunset to sunrise. Remember that fact. And he already had the requisite plan, the requisite intent, right? That he wanted to commit a larceny or felony therein. And remember, under the common law, a larceny was a felony. Therefore, again, he wants to steal Arnold's bodybuilding trophies. So once Riley does this act, he'll be liable for burglary under the common law. And one more thing I want to point out about this burglary under the common law, this is the last thing I want to say, is that the felony or the larceny therein does not have to be completed. So let's just say that Riley changes his mind once he already commits the breaking, the entering in Arnold's apartment during the nighttime, and he says, oh, I'm changing my mind, I'm too scared, I'm just gonna go home. Although he did not steal anything from Arnold's apartment, he will still be liable for burglary under the common law. So remember that. As long as he already had the requisite intent and he committed all these different elements here, he will still be liable for burglary under common law, although he did not steal anything or commit a felony within Arnold's apartment. Lastly, which is very straightforward, is the modern law. So the modern law simply got rid of the dwelling house of another, and the modern law just got rid of the nighttime element. So it can be any time during the day under the modern law, and it can be a structure of another. It can be a structure or a home. It could be really anything at this point. Okay, it could be someone's office. It could be someone's building. Example is the mall, right? Let's say that my friend Israel and Wade decide that they want to break and enter into the mall to steal things. Let's just say that, or even burn it down, right? That is an example of those two wanting to break into the mall. They enter the mall, and the structure is the mall itself, and they had that criminal intent, which I didn't write down here, but the criminal intent to commit a crime therein. Therefore, my buddies, Israel and Wade, will be liable for burglary under the modern law. The felony of arson can be broken down into two different things. In the common law, which I placed as CL here, and modern law, which is ML down here. So let's go through the common law version of arson first. Then we'll get into modern law. So common law arson means a malicious burning of a dwelling house of another. Dwelling house of another. That is the key difference between common law and modern law, is the fact that there is a dwelling house that's being burned. And an example of this would be Sammy's house, my house. So let's say that my friend Riley burns down my home where I sleep. That is an example of Riley committing the crime of arson under the common law. It must be a dwelling house of another. It can be an apartment, it could be someone's house, it can be even a homeless person's tent. As long as it is a dwelling of another, that is exactly what is needed for arson under the common law. So when we get into arson under the modern law, it is the malicious burning of a structure of another. An example, as you can see here, I put Target. It could be Target, it could be Walmart, it could be a gym, it can even be, your office at downtown St. Paul, Minneapolis. It doesn't really matter, as long as it is a structure and not a dwelling house of another. That is arson under the modern law. And what's key is that we need blackening in arson under the modern law. So it must be some type of charring that has occurred in order for a defendant to be liable for arson under the modern law. And when it comes down to arson under the common law, simply fire burning down the house. Very straightforward common law. Modern law, charring, blackening caused by the fire. When we get into robbery, robbery means a larceny committed in the immediate presence of the victim using either force or fear. Again, a larceny committed in the immediate presence of the victim using either force or fear. So what does all this mean? So the first element to really recognize here is larceny. Now, as you all know, and I'll say it again, larceny means the trespassery taking and carrying away of another's property with the intent to permanently deprive the owner of that property. I made a video on theft crimes, so if you want to know what all the theft crimes mean in your criminal law class, refer to that video. Committed in the immediate presence, element number 2, 1 and 2, immediate presence of the victim using either force or fear. So the defendant must have committed a larceny in front of the victim, in the immediate presence of that victim, by using force, whether it's physical or psychological, or fear. Basically using a knife, for example, to cause fear to the victim in order to scare that person to give up their property to the defendant. An example of this is, let's just say Donald Trump robs Hillary Clinton. Okay, Donald Trump is angry. He says, "You damn Democrats, always giving me a tough time." And he sees Hillary Clinton in the White House, and he says, "Hillary," he points out a gun, and he says, "Hillary, give me your purse." Hillary's scared, right? Because Donald Trump is using fear in her immediate presence in order to get her property, her purse. And Hillary doesn't want to get shot by Donald Trump or by anyone in that matter. Therefore, she gives up her purse to Donald Trump, successfully allowing Trump to be liable for robbery because he stole her purse, right? Larceny, stole her property in her immediate presence by using a gun to incite fear into her by getting her purse. And lastly, a second example is that let's just say that Donald Trump did rob Hillary. However, Trump just took her purse in her immediate presence using force. He grabbed it from her arms and he ran away. That is an example of Donald Trump, the defendant, using force rather than fear to complete the robbery. The felony of rape means the unlawful sexual intercourse of another against his or her will. It is a general intent crime, and this is important to know, that the slightest penetration of the penis will suffice. So the most common example is a man and a woman. A man forces himself onto a woman and he has sexual intercourse with her against her will. The slightest penetration, it could be centimeters, it could be millimeters, and it can last even for seconds. That will constitute the crime of rape. Moreover, what is not a common example is a man and a man. If another man forces himself upon another man, the slightest penetration of his penis will constitute rape as well. It's the same deal with a woman, except again, you just switch genders. So again, it must be unlawful. It cannot be consensual sex. And it must be against his or her will. Again, not consensual sex. And look out for the intent. Okay, again, this is a general intent crime, right? So if y'all been studying very carefully in class, you all know that voluntary and involuntary intoxication is a defense for specific intent crimes, right? So if the defendant is drunk or off some type of narcotics while committing this crime, the defendant cannot raise intoxication as the defense. However, a felony like robbery, like we talked about earlier, will be a defense for that because robbery is a specific intent crime. Okay, so mayhem is a very straightforward felony. Very straightforward crime, in my opinion. It's very, very rare to see in your criminal law course in terms of your written exam. However, it's somewhat common in multiple choice. So you still need to know it very well for the bar and for your class. This can make or break whether or not you get the extra 5 points in your exam. Think about that. So mayhem means the malicious maiming or disfiguring of another. An example of this is cutting off the victim's arm. So let's just say that Riley cuts off Israel's arm because he's angry. That is an example of Riley maliciously maiming Israel's body. An example of disfiguring, let's just say that Eric gets a baseball bat and beats the crap out of Snovik's legs, and Snovik is now paralyzed from the waist down. That is an example of the defendant maliciously disfiguring the victim. That is a felony. And last but not least, kidnapping. Kidnapping is a felony that will come out 50% of the time, about a 50% shot on whether or not it will be on your written midterm or final exam. However, I know for sure that kidnapping will come up on multiple choice. Whether your professor gives it to you or you see it on the bar exam, this is common. So the definition of this is the unlawful movement of another against his or her own will. The first element is the unlawful movement, which can be inches. It doesn't have to be miles upon miles. It can be even inches. And it must be of another, right, another person, and it must be against their will. So it can't be a situation where they voluntarily went with you and say, oh, he kidnapped me. No. It must be a situation where they forcefully went with you to a different distance because you forced that person to go with you. So it must be against their will. An example of this is, let's just say that Chris Brown is at a party and he finds his ex-girlfriend there and he throws her into his trunk because he's jealous, he's angry, he wants her back. And let's just say that she tries to resist him while he's grabbing her and throwing her in her trunk. That is an example of Chris Brown committing an unlawful movement of another against her will, because she didn't want to go with him, right? She was resisting him. Moreover, The unlawful move part is already self-explanatory because, again, we said that it can be inches, it can be feet. It doesn't have to be miles upon miles. As long as it was an unlawful movement of another against their will, that will constitute a kidnapping.